I also have a technical question. Maybe Ilya, you may want to address this, and obviously as a litigator, John.
I could see a judge saying, because the reading really could go either way, it's not a 100% slam dunk in my reading, I'm going to use the doctrine of constitutional avoidance to say, okay, with the fix, it'll be okay.
Do you think the courts, assuming the standing hurdle is overcome, will address the merits for the first time?
Well, if the standing hurdle is overcome,
and by merits meaning they'll say it's not a political question, it's a question that we're going to decide.
Well, in the 1990s, the court reached the merits of some appointment clause challenges where judges there was challenge whether judges were properly appointed under the Constitution, and I suppose the court could have avoided that issue by saying, your claim was not meritorious anyway, so if we'd have had a properly appointed judge there, then that would be, you'd have lost anyway, so no harm, no foul, we don't need to reach this constitutional issue. So I have some hope that if standing is overcome, and that's a significant hurdle, that a court very well may, instead of just looking and saying, well, you would have been denied your passport anyways, you confront the issue of whether the officer who did the denying was duly appointed. Will they necessarily? I have no idea, and I don't think anybody does.
Sure.
They very well could say, well, judges are different from cabinet officials, and make a distinction along those grounds, but I don't think anybody knows.
Do you think this is limiting in terms of the challenges? It's limited to this people supposedly aggrieved by the Secretary of State or actions by the officer holding it? Or are there other opportunities to challenge it?
If the Saxby fix is unconstitutional, then this is the Clinton fix, and so you could bring a challenge to this bill, not just to Senator Clinton's appointment.
And who would have standing to do that?
I think it's someone who's aggrieved by an action of the Secretary of State.
Right. It's kind of a circular argument.
Right. And we agree that the issue applies to Senator Salazar?
I agree with that.
And the other issue that might pop up, and we talked about it beforehand, but educate our audience here, Representative LaHood, who is in line for Transportation Secretary, a Republican, who presumably was in office at the time. I'm assuming the Transportation Secretary similarly had its salary raised.
It's all cabinet officers.
Tom tells me that Representative LaHood did not run for re-election in November. That's right. Then he's eligible. Well, the Emoluments Clause is certainly no bar to his appointment because, yes, the salary of the Transportation Secretary would have increased during his term in Congress, but the ineligibility ends when the members of Congress's terms end, and his term will end, I guess, January 3rd, so he would be perfectly eligible for appointment as Secretary of Transportation. Another issue that just came up, I saw yesterday that Senator Sununu was named by Senator McConnell as one of the appointees to the newly created TARP Commission. And if Senator Sununu were to be appointed and take that post this year before January 3rd, he would be ineligible for the same reason. That's an office, the TARP Commission is a federal office that's been created during Senator Sununu's term in Congress, so he would be ineligible until January 3rd, but I suspect he's probably going to take office after his term in Congress ends, otherwise he'd have to resign from the Senate first.
I should note that the Obama administration has already reduced government even before taking office, although I fear this is the most that they will ever reduce the size of government in creating 4 now Senate vacancies and 2 gubernatorial vacancies. So that's commendable in one sense, I suppose.
Now I'm going to throw a curveball because we're dealing with it every day at the office, and I'm sure in your day-to-day lives. If you're involved in constitutional issues, you may have been asked questions about this. But we talk about the eligibility of Hillary Clinton, and as you know, there's a great concern among some about the eligibility of Barack Obama and the enforceability and the court's ability to discern whether someone is eligible to be the President of the United States. Now, without addressing the underlying merits of the claim, is there an interesting case to be made that there's really, is there any, the courts to me have seemed to say that there's really no enforcement mechanism and it's a political question. Do you think it is a political question, and is there a vehicle at all for ever challenging the eligibility of a president in terms of citizenship status?
I'm going to defer to Ilya. That's just way out of my ken.
I haven't thought much about this, so like then Professor Breyer writing to Bork at the time, who said, you know, I haven't really studied this issue. I'm not an expert, but here's my opinion. I'm going to say, let's see, who could. I mean, it's part of the Constitution. It's clear as clear can be. Let's say that you know, I'm not yet 35. Well, I'm not a citizen either. So let's say I'm elected, right? Clearly unconstitutional. Clearly I'm ineligible. Who would bring that challenge? A voter, probably a voter, because their vote was, they've been disenfranchised, or something like that could be a theory. I haven't really thought through the standing issue, but if you can get around the standing issue, which I think is even more significant in that case than it is in this one, I don't see how a court could avoid doing that, because it's a facial violation. It's not some political dispute over one that we might have very shortly about whether the Senate seats Norm Coleman or Al Franken, you know, the result of the Minnesota senatorial election, you know, the internal machinations of the Senate and how they censure their own members. Things like this are clear political questions. Whether the Secretary of State recognizes some new independent republic, even though that's an action of, you know, Secretary of State. I'm not talking about some emoluments issue there, but there are certain things that are clearly political questions. On the other hand, this issue of eligibility for the presidency is a constitutional question. It seems to be a legal one. So as long as standing, I think, would be the most of the ball game there. I will not. I think even yesterday there was another cert petition that was beat back. Two more. Now we're at 6 or 7 about Obama's eligibility, and that's not that the Supreme Court is saying that it, you know, there's no standing or something. It just is affirming the lower court's decision, or letting rest the lower court's decision that for whatever reason the lower court threw those out, whether it's a 12b6, you know, failure to state a claim, or jurisdiction, or standing. I haven't looked at those petitions. So it's not that the Supreme Court has ruled that this is a political question that can never be ruled on.
I don't bring it up to promote the cause. I bring it up because the courts are ruling in large number on an eligibility requirement as it's stated in the Constitution, and there are a lot of people trying to figure out, well, whatever the underlying merits are, how is it we get the courts to rule on it? And no one's been able to figure it out yet. And it's interesting, some of our research found that some states do certify the eligibility of some other candidates for federal office, Congress and the Senate, but they're silent on the eligibility of the office of the president, which is kind of it may not be an issue now, but as our country becomes more diverse, and it may become an issue in the future.
I mean, I got calls earlier this year about McCain's eligibility because he was born on a base in the Panama Canal Zone before there was some sort of piece of legislation that formally did something. I mean, it's you know, U.S. servicemen parents. I mean, it's kind of absurd, and I'm sure his campaign had to spend time and resources researching that issue, or they got pro bono counsel to do it for them.